This is the Quintus van der Merwe story. He was one of the complainants at the HPCSA. The purpose of this video is to provide you with a countervailing account of the events concerning van der Merwe, which contrast hugely with the media reports. In contrast to the sensationalistic and vitriolic media reports, which are completely subjective, I'm going to give you my version of events with real evidence to support my story. Quintus van der Merwe is a 38-year-old Czech manager who came to see me on the 4th of October 2012 as he had a redundant fold of skin and fat in the lower tummy and fat deposits in the so-called love handle area. He was overall in good health and there were no risk factors to be concerned about. And as you can see from the photographs, he was an excellent candidate for what is known as a lipoabdominoplasty. In this procedure, the surgeon removes a lens-shaped piece of skin between the umbilicus and the suprapubic area, and then does a liposuction in the area between the belly button and the lower portion of the ribs, as well as the so-called love handles. The huge advantage of this procedure is that it's way less traumatic than a standard tummy tuck, and the recovery and ultimate results are superior. I sat him down and after examining him and pointing out where the liposuction would be performed, and then systematically explained to him what the potential risks and complications were associated with this procedure, as I did with every single patient. The most common complications are wound infection, scarring of course, and undercorrection or overcorrection of the areas to be liposuctioned, temporary or permanent alterations of the sensation in the area of the liposuction and in the skin above the suprapubic area, between the belly button and the suprapubic area. As with all patients undergoing liposuction, I explained to him that the areas of liposuction can be considerably bruised and swollen, and that it takes a full year before it is reasonable to assess the final result, and whether there might be areas that might require a touch-up liposuction, which involves costs. In practice, I found that it is very seldom that patients actually remember what I told them in the initial consultation, and very often they return for their follow-up visits and they could be somewhat concerned about the degree of swelling that might be present, and I always reassure them that the swelling would settle down as the months go by, and that they just have to be patient and to wear the pressure garment for another few months. I also explained to him that there are no further fees associated with any follow-up visits, and they are indeed welcome to see me every single day if necessary, if they're concerned, and that my purpose is there to help them and reassure them and intervene if necessary, should any complications arise. I performed the operation on the 5th of December 2012. The operation went smoothly with absolutely no complications or adverse events during or after the operation. He visited me the day after the operation and everything was normal. And then he visited me a week later on the 12th of December 2012. And I requested my nurse to snip off any sutures that may be visible around the wound. At this stage, it's worth mentioning that the technique I used to close the wounds was to use dissolving stitches exclusively in all the wounds, except the wound around the belly button, which I would use nylon stitches. That's like fishing gut. It was not unusual for a buried knot to resurface during the healing process. And if patients were concerned, they were encouraged to return and have them taken out. And very often, they'd snip the sutures off themselves with some tweezers and some nail scissors. After I saw him on the 12th of December 2012, he never returned for his follow-up visit, which was scheduled for 6 weeks later, which would have been about the middle of January 2013. The next I heard from him was approximately 9 months later, when I received a bundle of complaints from the HPCSA, 15 in total. And I'm now going to deal with the email that he sent to the HPCSA and Star newspaper. This is the email that he sent, and I'll go through it systematically and discuss each aspect of his complaint. As you can see from the title and address of his email, he sent it on the 13th of September 2013, a mere 9 months after his operation. It's somewhat bizarre and ludicrous that he could lodge a complaint at this stage when there was still at least 3 months to go for his swelling to settle down. You'll also notice that in addition to the legal department at the HPCSA, he's also copied the Star newspaper. It seems somewhat strange that he deemed it necessary to send his letter to the newspaper. Is this normal practice for a person complaining about his or her treatment to the HPCSA? It certainly raises some interesting questions. He states his name and about how he read the article in the newspaper about me. He then goes on to state that he is also a victim of Dr. Gordon. He stated that he had a lot of pain and thought it was normal for the procedure, which indeed it was. Having gone back to see me after a week and seeing me, he stated that I was very happy with the results, and I told him that the swelling would go down again and that I took his stitches out and closed his wounds again. In the next paragraph, he says that he went home and he discovered some stitches in the wound, and he phoned my assistant to inform her about it, and she said the practice was closing for December. In his email, he states, "She told me they were closing for December, but I have to come back in early January." As you can see later on in this video, he was asked by the prosecutor when he was led in evidence whether he was told to come back for a follow-up consultation, to which he lied under oath and said that he had not been given a follow-up consultation date. Now, the errant stitch in the wound certainly does not constitute a medical emergency requiring him to be rushed to hospital in an ambulance with sirens blaring. This constitutes a minor irritation at worst. He then states that he went to see his GP on about the 20th of December as he started smelling something and had unbearable pain in his abdominal area. The wound had gotten septic, as he put it. He then states that his GP removed the stitch and that Dr. Gordon had missed. The stitches were actually snipped off by my nurse and not me. Now at this point, I'm going to digress and discuss the issue of his going to see his mother's GP, who was Dr. Martin Fries, who practiced at that stage anyway, at 68 Central Avenue, Flamwood, Clarksturp. I recall from doing my internship, and this is drummed into young doctors at a very early stage, and indeed it is actually common sense, that should you have a patient coming to you who's currently under the treatment of another doctor, there's an ethical imperative to pick up the phone and call the doctor concerned and advise him accordingly that his patient has come to see him and advise him of the condition of the patient. In the ethical guidelines provided by the HPCSA, this is what the regulation is with regard to supersession, and it says, in terms of Rule 10 of the ethical guidelines, it states that a practitioner shall not supersede or take over a patient from another practitioner if he or she is aware that such patient is in active treatment of the other practitioner, unless he or she takes reasonable steps to inform the practitioner that he or she has taken over the patient at such patient's request and establishes from the other practitioner that treated such patient previously received, especially what medication, if any, was prescribed to such patient, and in such case, the other practitioner shall be obliged to provide such required information. No problem for Dr. Fries. He simply takes over the management of the patient and prescribes antibiotics and advises Mr. van der Merwe to purchase an infrared light. Now, in the 31 years that I've been qualified as a doctor and subsequently plastic surgeon, I've never encountered the use of an infrared light for the treatment of an infected wound. It beggars belief that a GP would have the absolute audacity to take over the management of a patient. And were I a petty and vindictive person, I would have laid a charge, or I would have complained of unprofessional conduct against him at the HPCSA. His conduct was egregiously violates the rules of professional courtesy and ethical conduct. Be that as it may, the infection probably resolved satisfactorily under the care of Dr. Martin Fries, and van der Merwe never returned for follow-up, for which reasons remain unclear. Why could he not come and see me? And if indeed there were any legitimate concerns, discuss them with me and air his grievances. This is what a reasonable person would do. And indeed, I would often see patients in the post-operative phase who were concerned about their scarring at about 6 weeks. And I would reassure them that with the passage of time, and over the period of about a year to 18 months, the scarring would settle down and be satisfactory. In any event, patients are advised that scarring is part and parcel of an operation, and that in the event of there being an adverse scarring, it is possible to perform a scar revision. Just cut it out, restitch it, and that will improve the appearance of the scars. Getting back to his email, he goes on to say, I have a scar so bad that I don't want to take my shirt off, and I still have love handles, which Dr. Gordon said would go away. I'm very dissatisfied with his service and would like to lodge a complaint. So this is the basis of his complaint, that he had a scar and didn't want to take his shirt off and still had love handles, which I said would go away. To this very day, his accusation has never been proved. Neither me nor my advocate nor my expert witness have ever seen this bad scar. The committee ruled that the complainants were not obliged to see my expert in order for him to compile a report and an opinion of the quality of his scars. The only people on the committee who have actually seen this scar are the doctors, and I was not permitted to inspect the scar and not have a look at any photographs of his terrible scars. Besides which, he was advised in both my consultation with him and in the consent form that scarring was a significant risk, and that in the event of it happening, it would be possible to revise the scar to make it look better. On the basis of this ludicrous complaint, every patient who is dissatisfied with the scarring of her cosmetic surgery can lodge a complaint with the HPCSA and would have to be removed from the role of practitioners. Not so? He concludes his email by saying, can you help me get on the right track and who I should contact in this regard? Quizzical question. Can you help me get on the right track and who I should contact in this regard? Kind of bizarre statement. Not quite sure what he's on about there. Let me now return to the timeline of the events of his operation. On the morning of his operation, he came in a good hour or so before the procedure was carried out. The standard protocol at the clinic was that the nursing staff would prepare the patient for the operating theatre, and part of the preparation involved explaining to them that they needed to read the informed consent, initial each paragraph of the consent, and sign the entire consent form at the bottom of the page. Here you can see the consent form that he signed in its entirety. But I'll now go through with each part of the consent. The first paragraph reads, "I'm satisfied that the surgical procedures as well as the anesthetic procedures have been fully explained to me, that my concerns have been addressed, and that my questions have been answered to my satisfaction, leaving me in a satisfactory position to weigh up the risks and to understand the limitations of the procedure." The second paragraph reads, "Significant potential complications of both surgery and anesthetic have been explained to me, and I've had the opportunity to discuss alternative treatment modalities. Complications include, but are not limited to, bleeding, infections, hematoma or blood clot, need for subsequent surgery, scar formation, local tissue infarction and necrosis, post-operative pain, prolonged pain, intractable pain, varied results, psychological alterations, embolism, depression, nerve damage, permanent numbness and slow healing." And I want to point out an area of his file cover that he signed when he first came in to see me. And having studied law and the doctrine of informed consent, I deliberately had a stamp made with the legal doctrine as well as explanation, and here it is, with his signatures clearly visible on the doctrine of volenti non fit inuria, and that it protects the practitioner from liability for an act causing injury to a patient which falls within the law of consent of the plaintiff, or in this case, the complainant at the HPCSA. The one who voluntarily agrees to suffer harm is not allowed to complain, for that once consent is given, it's a good defense. Basically, what it says is that if you've been made aware of the potential risks and complications, and one of the complications eventuates, you now don't have a case to come back and sue the doctor or lodge a complaint. So he had been he'd been made well aware of the potential risks both during the consultation and prior to the operation, and initialed each paragraph to indicate that he fully understood the potential risks. He then failed to follow the instructions to return for a follow-up visit and proceeded to lodge a complaint only 9 months after the procedure. As we go on further with the consent form, it says, "I acknowledge that I've had the opportunity to discuss the costs of the hospitalization as well as possible additional expenses which may arise should complications occur. I further acknowledge that I remain responsible for the payment of all hospital expenses, irrespective of any contract that may exist between myself and any third party, such as my medical aid." So he was well aware of the fact that should a complication occur, there could be additional costs involved, and subsequently failed to return for a consultation to discuss an amicable resolution of his grievances. In the next paragraph, which he also initialed, he states that, "I understand that no guarantee can be issued for an uneventful course of the procedure or subsequent recovery, but that the surgeon, anaesthetist, and nursing staff will take all necessary steps to reduce the likelihood of those complications occurring." And as you can see here at the bottom of the form, which he signed in full on the day of the operation. At this stage, I'm going to give you what I believe was the actual state of affairs and Van der Merwe's real motives. He obviously saw an article in the newspaper and the attorney mentioned, who's the common denominator in all of these cases. And I'll discuss the attorney's role in more detail in another video. But Van der Merwe spotted a potential opportunity to make a lot of money and sue me. He obviously went to the attorney with a view to launching an action for damages. And the attorney saw the scars and realized that there was absolutely no chance of any success in an action for damages. But rather than let that opportunity go, he advised Van der Merwe to lodge a complaint at the HPCSA. There is a lot more to this interaction between the attorney and Van der Merwe that is apparent at first blush, but I'll deal with that in another video. What I want to do now is to look at the other aspects of Van der Merwe's testimony, which, if it wasn't so tragic, it would be hilariously funny. Now, bearing in mind that Van der Merwe was led in evidence on the 25th of February 2016, over 4 years after the incident, it raises searching questions about the reliability and accuracy of his testimony. I'm going to devote an entire video to the issue of reliability of eyewitness testimony and how dreadfully unreliable a human's memory is, and how minds can essentially make up memories to be tailored to the situation. Also bearing in mind that all of the matters before the committee were based on the testimony of the witnesses alone, and there was very little evidence offered to prove their matters through the use of photographs and similar evidence. As you will see further on, the prosecutor chose to cherry pick and use photographs that had absolutely no probative weight. The photographs were taken literally days after the operation. Now, to give you an illustration of the gross factual discrepancies in his testimony, the prosecutor asked him about the first consultation with me on the 5th of December 2012. This is factually incorrect, as this was the day of the operation and not the consultation. He actually saw me on the 4th of October 2012, a full 8 weeks before the day he alleges he had the consultation. Now, before I go on to deal with the questions that were asked of him at the commencement of his testimony, I'm just going to explain to you what the procedure is when patients come in and fill out the file before seeing me. As you can see from the file cover that he filled out, he was asked to fill in the details of his name, address, telephone number, medical aid, and identity number at the bottom of the form, bottom of the file, and there's a heading entitled Medical Details. He was specifically asked to fill out any relevant information in the sections entitled Relevant Medical History, Previous Surgery, Current Medication, asking him whether they smoke, and then his weight and height. In addition to this, I used to ask a prospective patient specifically if there was anything that I needed to know that might affect my decision to operate. When he was being led in evidence, he was asked whether I'd asked him about his medical and surgical history, as well as any medication that he was taking. And he stated categorically, from memory, from 4 years previously, that I had not. During his testimony, he stated that he had asked jokingly whether he could get a six-pack, and I jokingly replied that of course he could. The prosecutor then went on to asking whether I had advised him of the risks and complications, and quite incredibly, he went on to ask whether I could guarantee that he would get a six-pack. Yep, absolutely bizarre, I know. He also stated that he was not advised of any potential risks and complications. This is what the prosecutor said next, which also beggars belief. We appreciate that this incident happened some time ago. If you still recall, on that day of the procedure, the 5th of December 2012, before any person could attend to you, did anyone say to you, sat you down and explained to you that you may die because of this procedure. Or it may go pear-shaped, the prosecutor's words, and that it may not necessarily work out the way you decided. Of course he stated that he denied it, I told him, which of course is a complete, blatant lie. And it's absolutely incredible that he can recall a doctor's consultation from some 4 years previously. Be that as it may, legally he signed a consent form, and let's once again refer to the first paragraph of the consent form. I am satisfied that the procedure, as well as the anesthetic procedures, have been fully explained to me, that my concerns have been addressed, and that my questions have been answered to my satisfaction, leaving me in a satisfactory position to weigh up the risks and understand the limitations of the procedure. Notice that he initialed this paragraph. Let's move on to the next section of the consent. Significant potential complications of both the surgery and the anesthetic have been explained to me, and I've had the opportunity to discuss alternative treatment modalities. Complications include, but are not limited to, bleeding, infections, hematoma, the need for subsequent surgery, scar formation, local tissue infarction, and necrosis. Postoperative pain, prolonged pain, intractable pain, varied results, psychological alterations, embolism, depression, nerve damage, permanent numbness, and slow healing. So he was completely apprised of the potential risks associated with the operation. Let's move on to paragraph 4 of the consent. I acknowledge that I have had the opportunity to discuss the cost of hospitalization as well as possible additional expenses which may arise should complications occur. I further acknowledge that I remain responsible for the payment of all hospital expenses, irrespective of any contract that may exist between myself and any third party, such as my medical aid. So he acknowledged completely the possibility of complications occurring, and that there would be additional costs involved. Let's move on to paragraph 5 of the consent that he signed. Notice that the paragraph has his initials in the right margin. I understand that no guarantee can be issued for the uneventful course of the procedure or the subsequent recovery period, but that the surgeon, anaesthetist, and nursing staff will take all the necessary steps to reduce the likelihood of those complications occurring. The prosecutor then asked him the following: yes, so when you were discharged, were you given any prescription, medication, or anything to take with? Lekker South African grammar, eh? Van der Merwe replied, he just gave me scar take and retin A cream. No medication, pain medication or anything, no. It is incredible that he has such an accurate recall of what was prescribed. And this is a barefaced lie. It is the policy and procedure of the anaesthetist to write a script for painkillers, and indeed scar treatment cream was given to them only once the dressings had been removed and micropore tape applied to the wound, and they were shown how to do it. Where the hell he gets this retin A cream from, God only knows, as I would only use retin A cream prior to doing a chemical procedure. After a dialogue about the stitches being removed and the fact that he hadn't been told whether they were permanent or dissolving stitches, and that the stitches had not been removed, he was then asked by the prosecutor, and was there any other consultation arranged with Dr. Gordon? To which he replied, no, nothing. Another barefaced lie, because the strict protocol in the clinic was to provide the patient with a card indicating the date of a 6-week follow-up, which he just didn't bother to return for. The prosecutor then asked him, now on that particular consultation, the last one that you had, did he tell you that he would be away on holidays and should complications arose, that there is a particular locum or that you should go see a specific doctor? To which he replied, no, he did not. And the reason for this is that simply I did not go away over the December period as a matter of routine, because this is the busiest time of the year, because people have leave and bonus pays, and I have to be available should any complications occur. Should there be a problem and they phoned my rooms, there was a standard recording saying that if there was an emergency, they were to proceed to the nearest casualty and ask the doctor on call to call me. This happened on the odd occasion, and invariably I was able to handle the problem should a casualty officer call me. And from time to time, I did go out and see the patient if I was concerned. He then went on to further say that he started experiencing unbearable pain, and a smell started emanating from the wounds, but that this was normal and expected part of the operation. He then recounted his experience of going to see Dr. Freeze, and I've already covered Dr. Freeze's highly unprofessional conduct in taking over the management of the patient and failing to inform me that my patient had come to see him. It was then that the prosecutor decided to show some photographs. Now it's convenient to show photographs that Van der Merwe said he had taken, but is it difficult to conceive that somebody could actually take photographs at such a distance? But we'll leave it at that. The first photograph that was shown was a photograph that he apparently took himself some 3 days after the operation. The prosecutor then goes on to point out various sections of the operative field, and where the tiny little liposuction stitches, where the metal tube was inserted to suck out the fat. And he refers to the bruising and so-called deformed navel some 3 days after the operation. On being asked about the very visible bruises in his flank area over here, which was treated with liposuction, the prosecutor laughably asks, were you told that one of the complications that may arise will be that you would be having bruises around your belly area? To which Van der Merwe replies, no, he was not. The line of examination got quite interesting towards the end of his being led in evidence, as the prosecutor asked him, is there any other thing of relevance that you want to place on record that you wish this committee to know about? To which he replied, I would like this committee to know that Mr. Gordon, I would like to refer him to as, I cannot see how he can ever be called a doctor, has taken a lot of my life away from me. I'm expecting a baby with Miss Scott, and I've only told her last week, after having me together for a very long time, what the real cause of the scar on my body, as I've always kept a secret from everybody. It has changed my life. I will never be able to take my shirt off in public, as I'm too embarrassed. And hence, I say, he has taken a lot of my life away from me. I live in Cape Town. I live right next to the beach. But I can never take full advantage of this. At this stage, it's worth mentioning that neither me, my advocate, or my expert witness have ever seen these terrible scars. The committee ruled that the complainants need not see my expert witness, which absolutely beggars belief. The doctors on the committee examined them, but I was precluded from examining the scars. No photographs were ever taken, and under cross-examination, Van der Merwe admitted to having read the consent and initialing each paragraph and signing the consent at the bottom of the form. My counsel asked him whether he had an opportunity to discuss the potential risks and complications, to which he answered, yes, he had, and that I had answered his questions to his satisfaction. It was then put to Van der Merwe that the photographs shown to the committee were photographs taken shortly after the operation, and he agreed with the statement. He was then asked whether he had taken any photographs 6 months to a year after the procedure. He replied that he did have photographs, but for some strange reason he did not supply them to the prosecutor for viewing by the committee. One of the doctors on the committee then asked whether he had recent photographs, to which he replied that he would, and he would go and search for it. But the chairperson of the committee suggested that the doctors on the committee be afforded the chance to have a look at the scar. Not me, or my counsel. Van der Merwe was vehemently opposed to my having a look at his scar. And we all duly trooped out of the room, and the doctor members of the committee viewed the scar. After they had a look at the scar, everybody trooped back in, and the chairperson asked the doctor on the committee, a GP, who had asked him the question about his scar, whether any photographs had been taken, to which he replied no. The chairperson asked the doctor whether he had any further questions, to which he also replied no. The proceedings were then adjourned, and then we got to lunch. When we got to lunch, my advocate said to me that the plastic surgeon on the committee had mentioned something almost in passing and in exasperation, that this witness had not been vetted properly. Now, the definition of the verb vet is to make careful and critical examination of something. The likely logical conclusion that I can draw from this is that the scars were certainly not as bad as he purported them to be. I'm willing to wager that there was absolutely nothing wrong with his scars, and that he probably has beautiful scars. I simply don't know, because to this day I've not had the opportunity to see the scars. But even if they were suboptimal, 99% of reasonable and rational human beings would understand that there is going to be a scar, and that some people simply don't scar well. He was also made completely aware and acknowledged the fact, the possibility of scarring, and that it could occur, and that it would be necessary to perform a scar revision. He simply never afforded me the opportunity to even have a look at the scars and to manage them accordingly. So, rather than return for a follow-up visit and discuss the possibilities, he proceeded to seek litigation, and when he found out that there was no cause of action to sue me, he was advised by his attorney to lodge a complaint at the HPCSA. So in summary so far, you have a 38-year-old male who has come in for an operation, and according to incontrovertible evidence, as evidenced by the informed consent, preoperative photographs, and postoperative recovery period, this operation went extremely well, and there were no adverse events or complications. He states that he contacted my rooms and spoke to my receptionist because there was apparently a stitch left in the wound. He makes absolutely no attempt to contact me or to find a doctor who would have made a plan to contact me. He goes to see his GP, to see a GP who promptly supersedes me and takes over the management of my patient. The GP never attempts to contact me. Van der Merwe lodges a complaint at the HPCSA at the behest of the lawyer, who wouldn't and couldn't institute an action for damages against me because there was no cause of action for damages. I'm going to mention at this stage that it is likely, if not probable, that Van der Merwe formed part of a very well orchestrated conspiracy against me. and that his actual motives for testifying were probably less than noble and ethical. I will cover this in more detail in a later video, which reveals the scandalous nature of the sham proceedings at the HPCSA. The committee passed judgment solely on the letter of complaint and the testimony of Van der Merwe and the expert witness of the HPCSA, Professor Annandale, and his testimony based solely on the letter of complaint to the HPCSA. No long-term post-operative photographs were ever shown to either the committee or myself or my legal representative. So you have a situation where a disgruntled ex-patient is hoping to gain some form of financial reward because he's supposedly unhappy with his scars. Now, even if he did have suboptimal scars, this certainly does not constitute unprofessional conduct. Would a reasonable person who's dissatisfied with his scarring not return to the doctor who performed the operation and say, "Doctor, I'm not happy with these scars. Are they going to get better in time? Or is this how they're going to look forever? Is there anything that we can do about it at this stage?" No. Van der Merwe never returns for a follow-up visit to express his dissatisfaction. Never picks up the phone to discuss with me. Never emails me the photographs. And never arranges a Zoom call so that I could have a virtual consultation with him and examine his scars. He proceeds to lodge a complaint at the HPCSA and copies his complaint to the Star newspaper. You also have a witness Van der Merwe, who's based in Cape Town and running his own business. And now, ostensibly using his own resources, in other words, he paid for the airfare and probably a couple of nights accommodation, to testify against me. He takes at least one day off and was probably prepared for 2 days off away from his business to testify, knowing full well that there were at least 10 other complainants who would testify. There's really something fishy going on here. I'm sure you'll agree. The attorney who spearheaded the witch hunt had corralled a number of supposedly disgruntled patients to complain against me. Of course, I naively believed that I would be vindicated and acquitted when these matters came before an impartial committee, and that the matters would be thrown out summarily. I believe that the absolute ludicrous and frivolity of the complaints would be exposed during the hearings, and that a committee comprised of reasonable, impartial members of the legal and medical profession, as well as the general public, would see through this farce. As the final outcome shows, this was not the case. And it, of course, raises some very disturbing questions about the fairness of the process. Much to my utter shock and dismay, the committee found me guilty of disgraceful conduct in Mr. Van der Merwe's matter. I've decided to make this part one of a series of videos in this matter, because I've been working on this for a very long time to prepare this video, but there's simply too much to put into one video, and there are so many deeply disturbing aspects of this case at many levels, and I'd rather cover this in a future video. I'll also discuss the chairperson's judgment as it relates to the facts that I've given to you in this video. So that's all for this video. Be sure to like and subscribe if you watched this far, so that you can be notified when part 2 is uploaded.